Hi, I'm Kellen Bryant, board certified elder law attorney, and I've helped thousands of families create durable power of attorneys, use them, and troubleshoot when there's problems. And in this video, I'm going to give you the step-by-step plan that I use in my office when looking for that next step when the power of attorney is needed. Let's get started. All right, let's go with step one, getting the original durable power of attorney document on and PDF file. So step one, you want to get the actual original document. Even though under Florida law, the original document's not legally required to be presented in most situations. Sometimes you're dealing with a customer service or frontline person at a financial institution, and they just insist upon seeing the original. And in that hassle, go ahead and have the original there and keep it. And if that happens, keep it intact. Make sure they don't take it apart on the staple, photocopy it, and return it with all the pages upside down and mixed up. You paid a lot of money for this document, so let's not mistreat the document. Ideally, you have that same document delivered to you in a PDF form, so you can say, oh, let me email this to you, and it'll be exactly how you see it. And from there, you will have good possession of the document. So generally, I recommend running it through the scanner so it appears clearly. So if the document itself, 20 pages, you're getting 20 pages with the signed blue, because blue is easier to determine the original, the signed blue on the very last page of that document. Upload that PDF file into something like a OneDrive or Google Docs, or a Google Drive, so that you can be able to easily distribute it, because the durable power of attorney document will need to be distributed many times, so make it as easy as possible. Step two, call the financial company or just show up. So once you have this original document and PDF file, in order to make it work, your loved ones or the person who signs the financial power of attorney, they're called the principal. You're going to need to go around to the principals, all their financial institutions, and figure out how do you share this document. And so any place where there's an account or you're dealing with your loved one's money, oftentimes you can't just say I'm a power of attorney and that's all there is to it. They're going to want to inspect it. And so this is a process they're going to need to go through. All right. So in this process that you are going to go through, you're going to have to go through this a number of times. So when you have your power of attorney, you're either going to need to show up at the bank itself physically with the document, or you're going to have to go through this process where you have to call the financial companies. So before you're laying the groundwork to do this, what I'm showing you is the spreadsheet I would use to manage the project. And I'm going to give you an opportunity to download this. It's going to be the first comment linked below. So once you need to go through and work with your loved one and the family and go through the mail, go through all the records, see what they got, figure out if they're online or not. This power of attorney process is going to make it official, by the way. When you use your loved one's passwords and logins, it's unofficial. And then you also get issues with multi-factor authentication where you have to use the phone in addition to logging in, and it just becomes clunky. The durable power of attorney process makes it official. And so you're going to need to go gather all the paperwork and see, here's the MasterCard statement. You need to put in the account number, and then you need to look on the back of the statement for the customer service number, and then you're going to want to call. And when you call to put the power of attorney on file, you're just going to ask them a very simple question. They're going to actually make you work through this process where they have you identify yourself, thinking that it's, say, your mother trying to call themselves on their own account. You may have to just skip straight to the operator and say all the steps needed to get to the operator. So on getting to the operator, I have in my spreadsheet how to get to the code. And you say press fine, say operator. Okay. So if you're trying to get a power of attorney on file, sometimes it won't take one shot. You have to call multiple times. And then once you talk to an operator, you're just going to have to say, I am named power of attorney for my mom. I want to put power of attorney on file so I can deal with you on the account. And they'll say, sure, let me help you with that. And they may say go into a branch if there is a physical branch. But if there is no physical branch, you're gonna say, is there a fax number? Is there an email? Don't be surprised if they say there's a fax number. And they'll say, yeah, you got to fax it in. You say, great, what's the fax number? And then you're going to get the fax number, and then you're going to put in the fax number. And you may need to do this in batches instead of going back and forth to an office supply store. or there's plenty of online fax machines. You can pay something like under $10 a month fax number to send it yourself from your computer. If you're not technology inclined, just plan on making if you were to use this, you're watching this YouTube video, so hopefully you can use some technology, especially if you got to the spreadsheet. When you're inside, if you have to go to a place to send a fax, it's best to send 12 faxes all at once and just go through the pile instead of going back and forth. So you want to track all your data of when you are submitting it. And the reason why that's important to get this on file is sometimes it doesn't happen the first time and you may need a reason to follow up. And after you submit it, you may have to, nothing could potentially happen for 3 weeks and you say, what gives? So you got to call back up. So if you did what I'm doing here and said, okay, I got to call back up. Where's the number? You're looking through the paperwork. You saved it on the spreadsheet. So you have it right here. And you say, what do I say to speed up this process so I don't have to listen to all these messages 5 times? All right, let's go through that prompt, say the operator. And then you say, hey, I submitted the power of attorney on January 5th, 2025, and I have heard nothing. What gives? How can we move this along? And they'll let you know if there's a roadblock and you might need to put additional documentation required. Because what's going to happen is when you call, they're not going to say in one shot a lot of times because you're not dealing with really sharp people oftentimes. And they'll just say, bring the power of attorney and send it this. But in their instructions, it may say, we need an ID, we need an affidavit, we need this, all legally required. So need to send copies of IDs for mom and me. So you need to put that in the documents and so that you can follow up all in one batch. And so that's how you would use this sheet when putting the power of attorney on file. Now, if we were going to a physical bank, a lot of times with the big banks, they're not often going to want anything short of showing up at a branch. And so when you show up at the branch, oftentimes you're not going to do it in one sitting. It may require 2 sittings because this exact process and steps I'm describing will need to occur at the bank level. And so at banks, you'll deal with the frontline customer service banker, not the teller, the banker. And the banker will need to send your power of attorney document off to the legal department for review. So you may need to plan on going twice for some of the banks. Now, the smaller banks or the more efficient banks will have either a more efficient process to do this, but the larger banks generally make you go in twice to get it done because they don't staff their legal department to review these things quick enough for you to do it all in one sitting. So what I mean by that is the person reviewing the power of attorney could be just one human being for all the United States, and it might take them 3 days to get to it. That's typically what could happen. All right, so now that you've arrived at the thing needed to get the power of attorney on file, you're going to present the power of attorney. And the main key for the next question and the next step is you need to also provide supplemental information. But it should be very limited in your mind. And if you get agitated, this is not a good time to get agitated, because agitation when using the power of attorney immediately leads some people to conclude that you're committing elderly exploitation and you will not get what you want by acting very angry and agitated. Okay, so when you present this power of attorney, expect to ask for your ID. And what they're doing is they're looking to ensure that the name on the document is in fact you, that you're showing up at the bank. So the problems that could occur with this is if your name on the document does not match the name on your ID, or you show up with an ID that's expired, photo ID, or you show up without a photo ID. Understand that most financial institutions are not looking to hold on to your money and just your loved one's money and be stingy about it. They're thinking that you're out to steal money and they want to protect their customer and make sure they follow the law to the letter to avoid liability for not properly following Florida law as relates to acceptance of durable power of attorney. So you'll present your ID to match up the name of the document, and they'll occasionally ask you for supporting documents. Under Florida statutes, which has been heavily revised in the last 15 years, the banks and financial institutions can ask you for an attorney opinion letter about its validity. They can ask you about a translation if it's in a different language. If it was done online notarization, they can ask you for the notary's information about the signing. And if they also are looking for an affidavit of attorney in fact, they can ask for that. So let me break down what an affidavit of attorney in fact is. So durable power of attorney only works when the person who signed it is alive. So on that affidavit, you're going to say principal is alive or if principal is not deceased. Second, there are legal proceedings to challenge durable power of attorney documents based on incapacity. And they're going to want to let you know, as you say, you're going to swear in this affidavit, hey, there's no legal proceedings to challenge this document or challenge capacity of the person who signed this document. So you're going to sign that. They're also going to sign and say, hey, this document has not been revoked. And so they're going to want you to sign that to protect the bank. If you were to proceed with the power of attorney at a bank when it's been revoked, you are breaking the law, but the bank wants out of it. And the person who signed that power of attorney originally, they proved you got that notice of revocation, there will be problems. The bank's looking to make sure that to protect themselves that there is no revocation. And those are the main issues that would cause the power of attorney to request, the banks to request additional information. Now, the banks at times will also request medical information. And under the Florida statutes, there is no authorization for banks to conduct an inquiry about whether or not this durable power of attorney document was signed correctly. If you're getting additional requests from the bank, use it with cautions. Also, the durable power of attorney statute was written to avoid this evaluation of capacity on the legal document. Once the durable power of attorney is signed, it's presumed valid, and whether or not the person who signed it is incapacitated right now at time of presenting the document. Foreign law had a lot of these durable power of attorney documents say this thing only works when there's incapacity, and so banks would say go get a letter proving the incapacity so that this durable power of attorney worked, but that's no longer valid in Florida since October 1st, 2011. So another thing that's very common that is requested is an additional form to be signed by the principal. And usually that's a form of power of attorney specific to that institution. And sometimes it makes sense just to play ball. If it's easy peasy, just go ahead and play ball. If it's not possible at this point to have your loved one sign a new durable power of attorney or that document, they can't make you do that extra protocol. They need to accept the original durable power of attorney document. You should not be stuck. And if you get a rejection on those grounds, that is worth pushing through with an attorney. So that's step 3. Moving on to step 4, wait for legal review and follow up. So after this frontline durable power of attorney presentation and supporting document exchange has occurred, the next step is the person you're presenting to will send it to their legal department. And during this evaluation stage, the legal department is actually looking at that boring middle of the durable power of attorney document. And if you're looking to say sell a property, if you don't have specific language in that durable power of attorney that gives you authority to sell the property, then what's going to happen is the title company, in my example, will say, hey, you don't have the power to convey this real estate. And that is required under Florida law. So you can't sign this deed to sell this property. The elderly person who signed this power of attorney is the one who needs to sign the closing paper. So those are the types of things that are looked for inside the durable power of attorney document. And that's where having an attorney created durable power of attorney has a vast advantage over the forms that you'll find for free online. The forms you find for free online often will be generalized blanket language that may not be up to date under Florida law. And because it's generally written for it could be generally written for all 50 states, or the person who's publishing these forms may not be a Florida attorney. They may be a Florida attorney, but they may not have ever used this actual durable power of attorney document up in the trenches and seeing what kind of responses that financial companies give in exchange in response to their legal documents that they sell and publish online. So the legal review team is looking to make sure that the person presenting the durable power of attorney is the person that's named, and they're looking to make sure the document's signed correctly, and they're looking to make sure that any additional protocols that in the documents that you have to produce are included in submission, and they're looking to see any other regulations that they may need to follow to accept the durable power of attorney. Now, step 5, you're looking at the response. So when you get the response from the legal team, if it's an acceptance, you may not be done. That's going to be the next step 6. So if they may ask you for additional information. And so if you didn't provide the correct information the first time when you submitted it, they're going to need to go back and provide the additional information. Or if the customer service representative said, hey, when you present this, you need to also provide or sign X, Y, and Z, that didn't happen, that's a time where they make you submit that information. Now, if the durable power of attorney is rejected, then it becomes a little sticky in what you do. And the durable power of attorney getting rejected should be an indication to you that you may need work and help from an elder law attorney to produce the durable power of attorney or respond to the rejection. Oftentimes, financial institutions wrongly reject the document. Sometimes where it's fine, somebody attorney knows what they're doing, who's done this a million times, they will make things up oftentimes to say why they reject it. That's completely out of left field, and that's the unpredictability of the law sometimes. And so an elder law attorney would need to review the written rejection, the durable power of attorney document, and see what was the hang up, and then push through any kind of roadblocks. Now, if the power of attorney gets rejected and an attorney cannot help you, you used a form online that was poorly done, and you can't get a hold of a bank account, are you stuck? Not really, but you'd have to go to a court supervised guardianship, which enacts another very expensive, complicated process. So that's why I'm a big fan of getting the power of attorney right the first time and not facing those rejections. And so that moves us to step 6. Step 6 in the process of using a durable power of attorney has you taking the action that you needed. So if the durable power of attorney is approved, you then can go do your directed action. So if you're looking to change an address, make a payment, get a payment, sell the property, change the account information, that can all take place. However, some banks and financial institutions will require that same review for each action you take. Very tedious, and that may be a reason why you want to consider consolidating accounts or going elsewhere. If the desired action is at, say, a federal government entity such as Social Security, OPM, they will reject your power of attorney on the front end. Those entities do not recognize state-level power of attorney. They require the federal process called representative payee in order for you to do anything regarding recurring income streams from the federal government. Now that you're done for that one account, now you're at step 7, which is repeat it for every single financial institutions, for every single transaction. And so and that's the important key of why I had that spreadsheet earlier, because you're going to need to do this for every single asset, every single liability, perhaps every single expense if we're trying to cancel expenses. Of course, there's other ways to cut off expenses, but oftentimes the big theory is we can't just take your word for it that you have power of attorney. So every company has its own process that you need to follow. And that's why I'm a big proponent of consolidating accounts at certain points of retirement, because doing this process with multiple accounts becomes onerous. Of course, if you have a lot of money, your loved one has a lot of money, yeah, you may need multiple financial institutions. But if we're talking, oftentimes what I see, someone's $300,000, $1 million or less, I'll see people with 20 different accounts where you don't need 20 different accounts to hide or hold $20,000 in each account and so forth. So consolidation of institutions is highly recommended in the world of estates, because after getting this power of attorney in file and your loved one passes away, power of attorney no longer worked, and now you have to do the exact same steps related to settling their estate. So it's much more efficient to have less accounts to do all these steps with. Now, step 8, organize. So now that the power of attorney is in file, now is the time to get organized and start getting lists of all the accounts and start getting a feel on how money is managed, who are the important people for your loved one in terms of CPAs, attorneys, financial advisors, insurance brokers, property managers, and so forth, and make sure that you understand how your loved one's money is flowing and whether or not you're getting a return on investment, and whether or not you have the cash flow and funds to pay for long-term care. So some couple frequently asked questions that I hear is, can I use a power of attorney at a bank or hospital? Yes, you can use it at a bank, but oftentimes, no, you can't use it at a hospital. A durable financial power of attorney is used for financial transactions in Florida. A designation of healthcare surrogate is used for medical decision-making. So the bank is going to ask for a durable power of attorney, and the hospital is going to ask for a designation of healthcare surrogate. So that often can be in one physical document, or it could be in two separate documents. Most common is 2 separate documents, because some people want to name one person for medical decisions and the other person for financial decisions. So does the power of attorney let me sell the property? Like I said earlier, there's many different actions you can take using a durable power of attorney. If the durable power of attorney document does not have the specific language of the action that you're looking to take, you can't do it. And that was part of the Florida law change. Formerly, the durable power of attorney document could be 3 pages. And on page 3, it says, the person I name in this document, he or she could do whatever I could do. And that's no longer allowed. So what we have to do now in our drafting is break it out granularly, one by one, things your person can do that you name as agent. And if you don't have it in there, you can't do it and you're stuck. And if you can't sign a new one. That's why I usually recommend new ones. Does the power of attorney still work of my loved ones in memory care? So as I said earlier, the durable power of attorney law changed in 2011. That made it no longer possible for the power of attorney document to have language that says this only works if I'm incapacitated. Now, if someone's in memory care and there's a durable power of attorney, now durable power of attorney, durable means that this document is not affected by my subsequent or future incapacity. So if my loved one's in memory care and it's a durable power of attorney, then your power of attorney will work. The last question is, can I pay myself or gift money? So the durable power of attorney you look to the document, the durable power of attorney statute in Florida has ways that the person named as agent, that would be you looking to use the power of attorney, can get paid for their time. And the document itself can explain how the agent can get paid for their time. Now, getting paid for time is different than gifting money. Gifting money on the durable power of attorney documents and under the current law change in Florida, October 2011, needs to say, my agent can gift money to my agent, even if it is self-dealing, there needs to be an initial buy. That's when you can gift money. And if there's a reason why you can gift money stated in the document, you need to follow it. If there's a limitation, like you can only gift up to $16,000, or you can only gift for medical reasons, then that's it. That's what you can gift money for. And on that provision of gifting, there needs to be initial, like I said, under the new 13 years old Florida law. Now, if you found this video very helpful, what I've done is I created that document that I showed you earlier. It's a spreadsheet where you would work through all the issues that I explained in this video in a nice, organized manner. And after working through that document, if you get stuck at any point, that's where you need an elder law attorney to look at the issue. And then once you have the power of attorney on file, then that's when you can start organizing. So thank you so much for watching. We'll see you on the next one.